Court of Appeal. We have one case on our docket this morning, case number 22-3148, Hope Hospice and Community Services versus Agency for Healthcare Administration et al. 20 minutes aside. I hear you're splitting arguments. I'll leave that to you to figure out. And when appellant's counsel is ready.
Good morning, George Levesque with Gray Robinson, and I'm joined by Ty Jackson with Holland and Knight on behalf of Hope Hospice. We would like to reserve 5 minutes for rebuttal, and Mr. Jackson will be handling the rebuttal argument. Okay. We're asking this court to reverse the agency's approval of VITAS's hospice CON application. There are three main reasons why I believe that this court should reverse. I'll briefly identify them first and then discuss each in turn. First, VITAS's application on its face did not seek a hospice CON license in the absence of numeric need under the special circumstances exception. That would be the first argument. The second argument is the agency's interpretation of not being served under the special circumstances exception as being the functional equivalent of underserved is contrary to the plain language of their rule and does not support the granting of VITAS's CON license. And then finally, the agency's rejection of the ALJ's findings in paragraph 44 was not based upon a lack of competent substantial evidence, and that is also cause for reversal. I can provide a brief factual background of the case, or I can just jump right in.
Yeah, I think we're pretty familiar, so go ahead and jump right in.
Can you first address, though, the standard of review? Is it arbitrary and capricious under 408039, or is it something else under 120.68 sub 7?
Well, I think in this, our arguments are really centered around questions of law, and so it's a de novo review. And I think it's one of those where there is no deference afforded at all. It's not a matter of whether the agency's interpretation is arbitrary and capricious.
Well, why would it be de novo? I mean, what's the basis for saying it's de novo? This is judicial review of an administrative proceeding.
It's judicial review of an administrative proceeding. In this particular instance, it's the action that we're challenging is the agency's interpretation of the rule. And under Article 5, Section 21, no deference is afforded to an agency in terms of the interpretation of a statute or rule, and it's de novo.
Sure, but what do we do when, I mean, which statute is governing our review? Is it 12068 or is it 408039? I guess start there.
I think it's, frankly, I don't think it's either one of those. I think it's Article 5, Section 21 that sort of trumps it all. But I believe it's also
Article 5, Section 4B2 gives us the authority to review administrative action as provided by general law, right?
It does.
So we're here only because the legislature said we can review this agency action, and they specifically said that in 408039.
It does, but Article 5, Section 21, which was adopted after, also provides what the standard of review would be, that no deference is afforded to the agency, and it's a de novo review process. Well,
but it still gets wrapped into, are you saying, so now with that provision out of the Constitution, we don't have to look at 12068 or any other statutory provision that gives us authority to review administrative action?
Not at all, but I think it does. The statute can't override the standard that's set forth in the Constitution.
Okay, so you are punting on, so it's neither statute applies here, and we're just kind of freewheeling it on what we're supposed to be reviewing?
That is my position in terms of what the Constitution requires, because I think Article 5, Section 21 was a game changer for the review of an agency's interpretations of statutes and rules.
So when the legislature says, and I guess I'll just quote it, that we shall affirm the final order unless the decision is arbitrary, capricious, or not in compliance with 408031 through 0.045. What does that mean?
There's
For
a
us.
difference between affirming the decision, I would argue, and affirming the agency's interpretation of a statute or rule that led to the decision in the first instance.
But isn't it the same thing? I mean, the only thing we're reviewing is the agency's decision. That's the thing that's on review. How they got there, I guess, is where the play is, but I mean, we have to start with, is it arbitrary and capricious, or is it under 12068 sub 7 dealing with misinterpretation of a statute or rule?
Well, I think how you get there matters, and how you get there is prescribed by the Constitution in Article 5, Section 21. And so on that path, that journey, that is the portion that the court has de novo review, their interpretation of the law. There's no deference, the Constitution is explicit and clear. There's no deference that is afforded there.
Okay. I guess, so if it's de novo a review of like, well, what does unserved mean versus underserved? But still we have to assess, there has to be some standard review for the order itself. And is it, so if they get it wrong, if we disagree with their interpretation, it's an automatic vacate, even though it may not have been arbitrary and capricious? Or are you saying it's an automatic vacate because there's a separate statute under 12068 sub 7 that says that we can set it aside if there's a misreading of the statute? There's two different statutes, and they mean different things. Arbitrary and capricious is different than what 12068 has this review for.
I understand. I think if the agency adopts an incorrect interpretation of the law and the court reaches that conclusion, it doesn't matter whether it's arbitrary or capricious or otherwise. I think the court is empowered to correct that interpretation and provide that relief. And I think that is derived from the Constitution. It's not necessarily prescribed by any particular statute.
Well, the statute also says, or not in compliance with the statutory regime, so there is an element of if they completely flood the statute, even that's wrapped into arbitrary, capricious, or not in compliance with the statute.
I would agree with that splitting of the hairs as well.
Well, but, okay, so if we're going to go with the statute route, which statute did they not comply with?
Well, in this instance, if they're adopting an interpretation of a rule, they're obligated to go through rulemaking. They've adopted a rule. But our position is they're not applying the rule. So in that regards, that would be the statute that they're not complying with. I don't think anybody has sort of contemplated going down that road. I think where we disagree is what's the significance of the interpretation of not being served. Does it mean not being served, or does it mean underserved? We believe the way that the rule is structured, not being served means not being served at all. It doesn't mean underservice. They use underservice throughout. They only use not being served in one section, and that's section 4D of that rule.
Does that get too hyper-technical of an argument? Let's say that they just put a cap. Okay, we're going to take 5 people from Hendry County this year, or 10 people from Glades. They're serving them, but they're not serving the community. They're putting a sort of a pro rata type deal, or it's available, yes, but not really.
Well, the way the rule is structured, and the agency writes their own rule, they start from the standpoint of the certificate of need determination. And based upon that determination, there's an unserved population built into that. So if there's less than 350 patients who are unserved patients, then there is no determination of need. The determination of need only kicks in when you have 350 or more unserved patients. So there's always going to be unserved need there. It's not a question of whether there is any unserved population or any unserved patients. It's a question of whether, under the exception, whether there is a specific terminally ill population that is not being served. In that instance, the exception would allow the granting of a license. Or if there is a specific county or counties that are not being served at all, in that instance, the exception would permit the granting of a license. But our position is not being served means just that. It can't mean underservice. If it means underservice, then you really don't need a determination of need at all, because anytime they can come in and demonstrate that there's some type of underserved population, they should be able to grant a license. That's not the way the language in the rule works. That sort of undermines the whole purpose of having a determination of need. But before we even get to that point, one of the things that I would argue is that when VITAS made their application, they made their application without identifying that they were flying under the special circumstances exception. In fact, specifically, they disclaimed it twice, including a reference that referenced the specific rule that said we are not seeking an application under the special circumstances. When you read the language of their rule, they refer to not normal circumstances. Nowhere do they identify special circumstances as the reason that they are proceeding.
But didn't the hearing proceed on that issue? I mean, isn't that what the parties ended up fighting over in front of the ALJ?
I agree that that's what they proceeded under, and they also proceeded under both a presentation of evidence that it covered both 1 and 2, but arguably the only thing that they ever really referenced in their application were Glades and Hendry as unserved counties. They weren't talking about specifically terminally ill populations, but there was evidence presented there as well. The point of that is, once an application is final, there can't be any amendment. And if they haven't said that they're proceeding under that in the application, the allowance of all of the evidence and the ALJ's ruling and the agency's ultimate final decision on that is effectively an amendment of their application to allow them to assert their claims under the special circumstances exception.
Are you making like a notice type of argument that Hope wasn't on notice because this application was worded a different way and Hope would have proceeded differently had they known?
It's not a notice application, although they're in following some of this CON litigation. Not normal circumstances is somewhat of an amorphous term. It's not used in the hospice CON statute, so one is kind of left to guess. But the real issue is, did they properly apply for a CON license in the first instance under the special circumstances? Our position is, based upon their disclaiming not proceeding under special circumstances and their failure to identify that they were flying under special circumstances anywhere else in the application, only sort of blindly referencing the provision in 4D, but describing it as not normal circumstances, a term that's not, or expression that's not used anywhere in that hospice CON statute. We believe they've failed to meet the requirements, and by proceeding and granting the license was effectively an amendment of their application, which would be improper under the Manor Care decision cited in our briefs.
No, it would be improper under, what would be the basis for our setting aside the order on that argument? Is it 120.68.7?
I believe that would be
I
believe that would be 128.68. Paren 7, I believe, yes.
Right. Or you're forswearing, I guess, 408.039 entirely. Your appeal is proceeding under that other statute?
Yes.
What do you think the purpose is, though, of 408.039 then? I mean, why have a specific provision that directs us to affirm unless it's arbitrary and capricious or fails to follow the provisions of Chapter 408 if there's already a proceeding? And it's very detailed, 120.68 sub 7. It gives us all kinds of criteria. that could justify setting an order aside. 408-039 is much more simple and straightforward.
Well, in this instance, it's not a question of necessarily just whether it's arbitrary or capricious. They're not, they've adopted a rule. The language in the rule is clear that when someone submits an application, and the application is deemed complete, by their own rule, in this instance, there should be strict compliance. It would be arbitrary and capricious if, and I believe it would fly under either situation, but it certainly would be arbitrary and capricious if you have a rule and they decide we're not going to apply it in this instance just because. The rule, it's black letter right there where the application is complete. There is no further information or amendment to the application that's permitted. Yet that's precisely what was done. And I've got one final argument that I would like to put on the court's radar, and that's the issue of the amendment to paragraph 94. We believe that there was a lack of competent substantial, we believe that there was not a lack of competent substantial evidence. In fact, when you read the order, the final order of the agency, and you read the expression or the exceptions that were filed by the agency in that particular instance, the agency was basically saying, look, there's other evidence in there, there are other findings in the final order that are inconsistent. We're doing this for clarity. We don't believe the changes were making it clear. We believe they were clearly intended for to revise that. We think the purpose of that was the way the agency was bolstering the final determinations related to the underservice. And so we do believe that was significant material, and for those reasons we would ask that the court reverse the agency's granting of the license.
Thank you, Mr. Levesque.
May it please the court, my name is Tracy George, and I represent the Agency for Healthcare Administration, one of the two appellees in this case. At this time, I'd like to reserve 10 minutes of time for our co-appellee, Vetus Healthcare, represented by Mr. Gabe Warren.
I'll let you handle that. You can stop when you...
I will do my best, Your Honor.
Very good.
So none of Hope's arguments in this case merit the reversal of the final order. The arbitrary and capricious standard is the main standard that applies. Everything else folds in underneath it. So if you need to consider whether or not the agency misinterpreted its own rule in order to be able to determine if our decision was arbitrary and capricious, that's how you consider it.
So you agree that 408-039 applies and not 12068?
I think it's the primary standard, yes, Your Honor.
Well, what's the secondary standard?
Well, as I said, I think if you were trying to decide, for instance, if we misinterpreted our rule, you still have to look at the other standard. But as to whether or not the final order is arbitrary and capricious and therefore needs to be reversed, the overall standard is the arbitrary and capricious.
But if let's say we disagreed with the interpretation of the agency's own rule, but there was a reasonable argument that the agency's reading was correct, and we just don't agree with it. Is it arbitrary and capricious if we disagree, but it's not an unreasonable reading? I mean, I think that's why it matters which statute we're under.
And that's something I know this court's interested in. We're all interested in understanding exactly what the constitutional amendment did. But I think that the standard that you need to apply is the arbitrary and capricious standard because that's the one that the statute sets forth. It's the most specific statute that applies. And I don't think we acted arbitrary and capriciously here. If you look at the regulatory scheme as a whole, it's all based on underservice and unmet need. And we would not have a 4D rule that relates to need that does not consider those things. Right, because it would be contrary.
But you do have a rule that already defines what, how many unserved individuals merits
Well, Your Honor, the whole
a CON. So what would be the point of having that number if, well, then there's this other section where you don't have to go through the numeric, you can just show that it's fewer than 350 and...
Okay, so 4D supplements 4A. What 4A does is it uses population comparisons to determine if there are 350 or more unserved people, and then if so, then there's calculated numeric need. What 4D does is supplements that, because there are certain factors that doesn't consider, right? It doesn't look at the distribution of people who have needs within the service area. It doesn't look at whether or not they all have the same illness. It doesn't look at whether or not they all have the same race. And so that's what 4D does. It allows us to look at those things. So if you meet 4A, then you have need. But if not, there needs to be a way to consider these other factors and make sure that we aren't leaving people out, because it's important that everyone who wants hospice gets the opportunity to get that service.
And the statute talks in terms of the need and availability for hospice services in the community.
Right,
So
we're
to
all
the
focused
extent
on
that-
community need, and community need can't be determined always just by looking at numbers. Sometimes you have to look at who's being served and who's not.
Counsel, if we find that the final agency action in this case was not arbitrary or capricious, do we get to your secondary analysis? In effect, does that end the discussion?
Your Honor, I think that I don't think it's necessary to look at paragraph 94. We know that doesn't really change anything. It didn't have anything to do with the specific circumstances analysis. The other argument they advance, everybody knew we were talking about special circumstances in this case. Their own witnesses said that. I don't think you need to go there. I think the heart of this case is the interpretation of the rule and whether or not we ended up with an arbitrary and capricious decision as a result of it. And I don't think if you look at the regulatory scheme as a whole, you could come to that conclusion, because there's just that's the focus of the certificate of need. We don't want too many hospices, because that means people aren't served well because there aren't enough resources. But we want everyone's needs to be met. So when you're looking at the need determination, you're determining is there need, and then you go on and weigh the other factors. Matter of fact, if we had a case back from 2014 where 7 people who had unmet needs were enough to establish special circumstances because of the type of need that they had, but the project wasn't financially feasible, so the COM was denied. So I mean, all these things work together. It's all a weighing and balancing. And when you look at it all
What's the import of the
together,
application in getting this process started? Here, what's the importance of the application itself? Here, the application said this is not about special circumstances. It did so explicitly in a couple of places. However, it did talk about not normal circumstances or some such thing.
And it cited paragraph 4D.
So is there discretion there for the agency to figure it out, or is this essentially allowing an amendment of the application that's not permissible?
If you look at 408.049 subsection 5, it says that the application must be substantially compliant. We think this application was substantially compliant to show special circumstances. It even cited to paragraph 4D. It laid out everything that they needed to establish special circumstances. It just called them not normal.
Well, how hard is it to pick, I mean, why mess around with the language? Why use a different term that's not found in the rule, cite a different rule, say, yeah, we're not proceeding under D, and then say,
Your Honor,
and then go to hearing and now proceed as if it's special circumstances?
Well, Your Honor, I'm not the one who advised their client on how to write it, but, I think that they've done enough here, and the agency could see what the special circumstances were. The judge could see what the special circumstances were. Everything that they brought in at the hearing related to what was already alleged in the application. So I don't think there's any real argument that they didn't allege special circumstances in the application.
So the agency has some flexibility to look through the terms of the application to see what's really going on and to administer the application on that basis.
Yes, Your Honor. Again, the standard is substantial compliance. Is the application substantially compliant with the requirements of law? And I think they were here because they did allege what they needed to, even if they called it the wrong thing. And if you look back through the case law, CON practitioners and judges, they tend to refer to special circumstances and not normal circumstances interchangeably a lot because of the way that different portions of the CON law have occurred over time, and it's almost a colloquial thing. Now, they wouldn't necessarily be the same thing in every case, because we do have those subsections that talk about not normal circumstances. But those are reasons why we wouldn't grant a CON, not reasons that we would. Right?
I think if you take Hope's arguments collectively on appeal, it seems like what they're really saying is that the agency seems to be bending a lot of rules to get to a certain outcome, to get a CON. What's your, generally, what's the, it does,
I don't think we've
overlooked the agency overlooked the, sort of these deficiencies in the application, maybe they're not substantial, but then, it's the underserved versus unserved, and, what's generally the
well,
response to that?
underserved versus unserved, I don't think there's a difference between those. I mean, as Judge Osterhaus pointed out, if you're talking about, you can get around the rule by serving one African American or one homeless person or one person in the service area, that's not a good rule, and that's not what the rule means, right? That's contrary to the entire rest of the statutory scheme. But I don't think we bent over backwards for Vitas here any more than we would for any other applicant. I think we just looked at what did the application allege, what was brought in at the hearing. The ALJ found that they met all the requirements of law. This is not just ACCA's determination. The ALJ found all the evidence was there.
Well, yeah, let me flip it around. How would you describe, what is the fundamental responsibility of ACCA in this process for CONs for hospice? Like, what is the role?
The role is
Ultimately.
to do what the legislature's told us to do, which is try to make sure there's not too many hospices, but that we're meeting all of the need that we can. And what we just don't want is we don't want to grant applications willy-nilly and not have enough people to help the hospice perform its function, but we do want to make sure that everybody who wants hospice can get it. And here there were a bunch of reasons, a bunch of special circumstances. You had, the ALJ found there were low utilization rates in 2 counties. He found that non-cancer patients, homeless patients, and Medicaid and charity care people weren't being served. He found that people who wanted hospice in the home weren't being served in all 3 counties. So, this is a situation where we think there was enough need here, right? And these people need services. They need the choice to have services in the home.
And does that loop back around to, I think, what I asked initially, which is the assessing whether this is arbitrary, capricious, as opposed to other agency actions, other agencies, and under 12068 and that kind of review?
Your Honor, I think arbitrary and capricious is a pretty high standard to meet. I don't think you can say that we're acted arbitrary and capriciously when we had reasons. And we had good reasons, and they were supported by the statutes, and they were supported by the rules. At this time, I'd like to allow my co-counsel.
Thank you, judges. Gabe Warren, along with my partner, Steve Asenia, for Vitas Healthcare Corporation of Florida, co-appellee with ACCA. I want to follow up on some of the things that Ms. George said and talk about this notice application issue that the panel has honed in on. Just for some historical context, not normal circumstances, as both sides have pointed out, is not a term found in any statute or rule. It's an industry term that was developed essentially to mean need outside of numeric need. It was this free-form opportunity to show need where there was no numeric need found. It dated back to the old hospice CON applications. That's where this term came from.
Now, do you agree that there's sort of 2 categories by which you can be approved, numeric need and then special circumstances, or are there other?
There's at least 2, Judge. I'm going to try not to get into more than needed today, but at least 2. And in the hospice rule, what ACCA's done is specifically identified specific not normal circumstances in 4D. And that's why, because this term has effectively been used for years, that's why every single witness that was asked about it in this case agreed. Two former and one current ACA CON unit chiefs all said these terms are used interchangeably. James McLemore said, yes, these terms are used interchangeably. Marisol Fitch, who testified for VITAS, former CON head, said, yes, these are used interchangeably.
Was it a mistake to mark that this isn't a special circumstances case, or to say that a couple of times in the application?
I'm not sure if it was a mistake, Judge. I think it may have been more semantics. That was the term that the consultant who put this application together was familiar with based on her lengthy experience with CON in Florida. That was the term that she chose to use. Do we wish that she had said, yes, we are seeking approval under special circumstances in that one small piece of the application to avoid the confusion that we've seen here today? Yes, of course. But if you look at, I just want to turn your attention to, there's a number of citations in the rule that or in the application, that directly connect the application to 4D. That's 755, 780, 900, 951, 952, 972. The executive summary for the application itself states right off the bat, VITAS is applying for a CON under the not normal circumstances set forth in Hospice Rule 59C 10355 4D in order to address the unequitable access to hospice services in 8C. It makes clear right from the beginning, not normal circumstances in this application means 59C 10355 4D. There's a number of other references just like that linking the term not normal circumstances with 4D. I'm not going to go into all of them here. I know we're short on time. The application also spells out both prongs as a basis for approval repeatedly. We've got those cited in our brief. Hope's attempt to link not normal circumstances just doesn't connect. Attempt to link not normal circumstances to three other provisions in the rule that reference the term not normally approved just doesn't connect. Ms. George touched on this. Those are examples when, even if you have a numeric need, the agency will typically not approve those applications. It's when you've got a hospice provider who has been licensed within the last 2 years, even if there's a need shown under the numeric need methodology, the agency won't normally approve there. It's if you've got a hospice who's been approved but not licensed. Neither of those applied here. Hope Hospice has had a monopoly for nearly half a decade. There was no other hospice applicants, even remotely in the realm. And the third one is for a freestanding inpatient unit. I've not heard any allegation from Hope that this was an application just for a freestanding inpatient unit.
So your position is if either a terminally ill population is not being fully served, then that population is not being served, or if a county within the service area, so here 8C, is not being fully served, then they're not being served. Is that the position? Not being served and being fully served are equivalent terms.
I'm not sure I'm willing to go that far today, Judge, that fully served and not being served are exactly the same thing. I think there is certainly some overlap in that Venn diagram. I think the key...
those are the two criteria. You have to meet one or the other of those criteria, even under special circumstances rule, right?
Right, to show that a specific terminally ill population is not being served or that a county or counties
Right.
are not being served.
So obviously you don't take the position, you don't agree that if one person in that population is being served, then you can't say that it's not being served. I think that's Hope's position, right?
We
So
absolutely disagree with that.
what is the criteria for assessment as to when, how do you read that term, or how should we read that term?
Yeah.
If it's not fully served, because now you're saying it's not the equivalent of fully served, well, how much short of fully served would then constitute not being served?
And I think you've gone to the heart of the issue, Judge, and it's a tricky issue, and it's hard to put a bright line rule on it to say you've got to show there's 10 non-cancer patients or 15 homeless veterans who are not being served. That's what ACA's done in the numeric need methodology. It's a much more difficult task in 4D, which, as Ms. George explained, is essentially trying to find where has the numeric need methodology failed? Where are the specific subsets, be it terminally ill populations or counties, that are not being counted appropriately in that numeric need methodology? And I'm not sure I can sit here today and give you a bright line rule there.
Well, but you're still back to the question of, well, what does it mean to not be served? So if it's a population or a county not being served, that has to have some meaning, and your position is the meaning is not, it has to be more than just one person being served. But your position is also, well, it doesn't also have to be short of being fully served to constitute not being served.
Yeah, that's, unfortunately, that's right, Judge. What our position is that it's obviously more than one. That would stand the rule on its head, right? If a provider could show what
I
we're.
think your counsel is trying to get you
I'm sorry.
a message.
Thank you, Judge, and thank you, Ms. George. Yes. What Hope Hospice is trying to do is stand the rule on its head, right? They want to make it about what they're doing. They don't want to make it about what is not being done in the service area. And so what the task of ACA and the ALJ, ultimately, if it makes it to hearing, is to weigh and balance the statutory review criteria, which the legislature specifically enumerated 10 or 11 separate criteria that you have to consider, and you weigh those simultaneously with the criteria in 4D to make the determination, is there a need here? Is this going to benefit the residents of this county? Can I give you a number today? No, I can't. But that's...
But specifically, counsel, though, are the terms underserved and not being served used interchangeably in the industry? Are they the same? Are they different?
Judge, good question. Again, I think there is some overlap in that Venn diagram. We know ACA uses the term unserved in 4A as part of the numeric need methodology. So certainly there is some difference in unserved. We know that's not being served at all. Hope Hospice wants you to read in additional language to not being served. They want it to mean not being served at all. That's not how it's used. It's used as not being served. What does that mean? We're not meeting the needs. Does that mean we're serving one patient? Is it 10? We have to look at the evidence of the service area of that population as a whole and determine where is the rest of that iceberg beneath the water, how much of this population is not being served by the existing provider. I see I'm almost out of time. I just want to leave you with one last thought. Hope Hospice essentially wants you to weaponize this rule, to stand it on its head, to protect its monopoly, and to prohibit any competition in its service area. They want you to restrict access to residents in Service Area 8C. That can't be right. Thank you for your time, judges. We ask you to affirm.
Thank you, counsel. No, that was good.
Thank you. May it please the court. Ty Jackson on behalf of Hope Hospice. I want to start first with the standard of review here, and I'll read from Big Bend Hospice, Inc. versus the Agency for Healthcare Administration. This is from the first DCA, 2005. It's 904 Southern 2nd, 610. Last paragraph, we read section 408.0396B in parameteria with section 120.687 and conclude that 408.0396B is simply a restatement of the standard of review set forth in sections 120.687 generally. Goes on to say we're going to defer to the agency. Of course, that's prior to the current constitutional amendment that we have. Your Honor, I would posit to you it's not an arbitrary or capricious standard here. The statute says arbitrary, capricious, or not in compliance with sections 408.031 through 408.045. The rules we're talking about here, both the special circumstance rule and the rule that says you can't amend your application after it's complete, are adopted under Chapter 408. If they're not applying those rules as they're written, they're not applying them in compliance with 408.035 through 408 or 031 through 045.
So is there a threshold determination for us on this, on the unserved versus not being served, or not being fully served versus being served? There's a threshold determination for us as to whether giving services to one makes you good for the whole county type deal. But once we think that might be a loser argument, then we get into this area where there's this balancing that goes on where they have to decide whether our population's really being served or not, and how big is that, and is that a concern or not? And then is it on us to then apply that arbitrary or capricious standard? That basically the agency gets to make that call if we're not talking about if you serve one, you're good.
Your Honor, I think you're right to the extent that I think the first issue, I mean, if you decide, I think VITAS failed to apply under special circumstances, they said that in their application, but if you decide, hey, they did, and that's not an amendment to the application, which I think it is, but if you decide that, I think it is incumbent upon this court to decide, what does the rule mean? Is not being served mean not being served, or does it mean underserved? You have judges, administrative law judges. Judge Newton currently, within the last year and a half, has said not being served means not being served. It doesn't mean underserved. Well, you have Judge Cohen in this case saying that not being served means not fully served, not adequately served, not served at the statewide average, a bunch of different standards. What is the standard? And Your Honor, I would posit the standard is a high one for a reason. Unlike acute care hospital CON, where you didn't have a numeric need methodology, you do for hospice. Not normal grew up in the acute care hospital world where there wasn't a fixed need pool number. Here we have a formula. ACA has said, here's how we determine need. If we show that there's no need under our formula, then, and you can show us that people are not being served, we're going to let you come in. It's an exception to the rule, and it should be a high standard, Your Honor. And I would suggest, yes, we need this court, and not for just this case. Like last cycle, there was no need anywhere in the state. You still have applications being published or being presented for the agency. We need to know, what's the standard? I think the standard is not being served, and the ALJ in this case did not find that a single patient was not being served. In fact, at paragraph can't cite to the paragraph, Your Honor, but there's a paragraph in the recommended order where the ALJ specifically says there wasn't a single patient in this case that I found that wasn't getting service. So that was, and unless you let them overturn paragraph 94 and reverse its meaning, taking it from a statement of the ALJ's finding to simply a restatement of one party's position, which completely eviscerates that finding, he says, I don't buy the argument that they're not being served in Glades and Hendry counties. Nowhere else in the order does it talk about patients not being served. It simply talks about underservice. I would posit to you that's not the standard. No patients are not being served in this case, either counties or populations, and there's no basis, no finding of fact upon which to find that the rule requirements are met, even if the application was filed under that threshold.
Thank you, counsel.
Thank you, Your Honor.
We are adjourned.
All rise.